Hello everybody, I'm Mithilesh representing Kanuni Salah, justice seeker to lawyer, and today I'm supposed to discuss about writ. So there are five kind of writ. When a court, the apex court especially, issue order to the lower court and the state, and even a private party. So there is mandamus. It means issue order. Second is certiorari. It is order of the apex court against the lower court or tribunal if the lower court has surpassed the jurisdiction or given false judgment. In that case, certiorari is applied by the apex court. Third is prohibition. It is also against the lower court, but which is under the progress. If case is under the progress, the apex court can apply prohibition to stop the proceeding because of wrong proceeding is taking place. Fourth is quo warranto. Quo warranto means with what authority? Any state authority, tribunals, or any government authority, if doing beyond their duty or authority, then quo warranto is applied. Fifth is habeas corpus. Habeas corpus is a writ which is applied for government authority as well as private party. It means we have to present before the court, and court issue the writ against the illegal custody. So habeas corpus is applied for private party too. Arrest is applied for the state court. Mandamus and quo warranto is against the state. A state means the government organization, society, tribunal. These all are come under the state, where funding is given by the government. Then that is called a state. And who can file writ? Those right, fundamental right is trampled, overpowered, and negotiated and minimized. In that case, the aggrieved person can go to the court with certain petition, writ petition, to get the writ. And even a third party can apply for writ on behalf of a group of aggrieved person. They are not speaking or going to the court. On the public welfare, a person or organization can proceed for writ. Then that kind of petitioner is also applicable. And the concept of PIL is also there. If an organization or person is moving in favor of a group of people or public where their right, fundamental right is negotiated, minimized, limiting by the state, then PIL can be filed. So this is about who can file a writ. What is the process to file a writ? And what are the expenses one has to bear if looking to file a writ? If you go for the cost of expenses of filing the writ, there are three kind of categories. First is lawyer fee, advocate fee first. Second is court fee. Third is documentation charges. So there are three categories where fee applied, but cost applied for filing writ. And there is difference between filing writ with Supreme Court and High Court. Under Article 32, we can file writ with Supreme Court. Under 226, Article 226, you can file writ with High Court. So High Court writ is a wider scope because under Article 226, you can file writ when your fundamental right is trampled as well as your legal right is limited, minimized. Then we can file writ under Article 226 with High Court. And with Supreme Court, even Article 32 is the part of fundamental right. So they can directly file to Supreme Court. But there is focus scope, like there should be overpower of fundamental right. Somewhere your fundamental right is negotiated, then we can go for Supreme Court. So that is the difference between Article 32 and Article 226. What is fundamental right? Fundamental right is a right which we get just after having a birth as being a human being. Certain right is protected. In Constitution Part 3, which is about fundamental right, Article 15 to 14 to 35, let's talk about the fundamental right. So this is about writ, and your right is somewhere negotiated. Certainly we can move to the apex court. Being a citizen of India, law is above all. And petitioner is completely protected. There is no such thing that those who become petitioner, they can be mishandled, misused by the authority. Case is not like that. Thank you.